Shri P. Wilson. 5 minutes, sir.
Sir, this bill amends and introduces Section 3G to establish a tribal university in Telangana with the budgetary provisions of 889.07 crores for 7 years in 2 phases. Thank you, Chairman, sir. I will talk on this. Sir, so far as this repealing bills are concerned, sir, it is better to have a sunset clause in all the bills. Whenever you introduce a bill, you should have a sunset clause so that once the bill is introduced and act is passed, that sunset clause by itself, the bill becomes defunct and it amounts to a repeal. So this sunset clause has to be introduced so that we can avoid this much of valuable time in future for having a separate repeal bills. I understand whenever you bring in an amendment by way of an act, that amendment act will be there and it can be repealed only by a repeal act. So when you introduce this type of sunset clause in the bills, that will help us to save much time of this House and we can debate on the people's issue, number one. Sir, so far as number two is concerned, sir, whenever you bring an act, why don't you consult the stakeholders? I have seen, sir, I have been in the Committee of Law and Justice. Sir, the judiciary is taking the strain of hearing or because of the act which is being brought. So why don't you have a judicial impact assessment being done whenever a bill is introduced into the House? Before a bill is introduced into the House, why don't you have a consultation with the stakeholders, consultation with the judiciary, consultation with the advocates, consultation with the persons who is going to be affected by the bill? So, for example, I would say the Negotiable Instrument Act, when you brought an amendment, Section 138 of Negotiable Instrument Act, it had a docket explosion. All of a sudden, lakhs of cases overnight, the courts have to hear. So there was not much of infrastructure. And our Honorable Chairman, I would say with pride, he belongs to our community, namely from legal fraternity. The Chairman knows that if you introduce a bill and when it becomes an act, how far it is going to have an impact on the judiciary, on the litigants. So this study can be done before a bill is being introduced so that it will not be a surprise for all of them. If you want to bring an act which is going to affect a trade community or it is going to affect lawyers or other set of peoples, so why don't you have a hearing and tell them, and so you can also interact with them and they will also be suggestion. No, why I am saying is, there are a lot of amendments being brought. Sir, I will say today, take Arbitration Act, sir. Sir, under Section 34, if you want to set aside an award, the court which is hearing a matter against an award passed by an arbitrator, it has no power to modify a decree. It has to only set aside and send back again to the arbitrator. Sir, arbitrators are taking about years together. Imagine an arbitration goes on for about 5 years. And when the matter comes to the court and the court hears the matter, and after another 5 years, if the court is not empowered to modify award and make it as a decree, and the power is only to the extent of sending it back to the arbitrator, sir, these types of powers, sir, has to be regulated by way of having a discussion with the stakeholders whenever before it is being introduced before the Parliament. So that is what, sir, I would say, that these repealing acts are unnecessary. You can stop it by introducing a sunset clause at the beginning itself. So that would be my suggestion, sir, so that we can avoid, the wastage of time of this House. And if this sunset clause, this has been followed in the foreign countries, I could say. So this can be adopted, and we could save time. We can concentrate much on the people's issues, and the other issues can be taken into consideration. Number one. Sir, another important issue, sir, which I have been telling you is, sir, the social diversity is not there in the judiciary, sir. When you take the representation of the number of judges in the High Court or the representation in the Supreme Court, sir, the social diversity is lacking in the High Court, and it is also lacking in the Supreme Court, sir. Please see, sir, the information given to the Parliament by the Ministry of Law and Justice. If you see from 2018 to 2023, sir, I am told that about 80% are from the upper caste. I would say from the one community. I don't want to name the community. And the rest of 20%, sir, are coming from the backward class and from the scheduled caste and scheduled tribe. And if you see the Supreme Court, sir, is still worse. So we had, in fact, sir, we had even brought a report.
You made your point, sir. Very, very emphatically, you have made your point.
Yes. So I would only ask the, I'm grateful to the chairman. And this representation, why don't you consider, sir? Sir, what is wrong with a backward class person coming as a judge? And do you think that he can't deliver judgment? Sir, I can see two things, sir. Whether the collegium has failed to identify a person with whose merit from other classes, or whether the collegium is not interested in identifying a meritorious persons from the other classes.
You have made your point, sir.
So therefore, high time, Chairman, sir, that let this be considered. And thank you very much for allowing me to speak on this bill.